Welcome to this explainer. Today we're diving into a high-stakes legal battle that really gets to the heart of a fundamental concept in law. How do we balance a person's right to a speedy trial against society's absolute need for justice? I mean, how do we ensure fairness when the wheels of justice are just grinding so incredibly slowly?
So how long is too long to wait for your day in court? Just imagine waiting literally years for a trial to even begin. Your reputation is completely on the line, your everyday life is just totally upended, and the stress is constantly mounting. This right here is the very human dilemma at the center of the constitutional puzzle we're exploring today.
Okay, let's look at the timeline. December 1994, arrested and remanded. August 1995, the decision to prosecute. May 1996, a formal charge sheet. And finally, November 1996, a court application to stop the trial. The man at the center of this is Bruce Robert Sanderson. He was a prominent deputy head of a primary school, a well-known local singer, and he suddenly finds himself accused of terrible crimes involving two young girls. As you just heard, the clock started ticking in December of 94, but it took until May of 96 just to get a formal charge sheet. By November, after all these delays, he makes a desperate application to stop the trial entirely.
To really grasp the gravity of that timeline, listen to what Sanderson said in his own affidavit. He describes suffering from anxiety and stress of such severity as to necessitate the use of medically prescribed tranquilizers and sleeping tablets. That's a devastating human toll. The negative publicity severely harmed his reputation, his stage performances were canceled, his wife's business took a massive hit, and he was just consumed by the sheer anxiety of waiting for the system to actually move.
Section 25, 3A, the constitutional right. Let's see how all of this builds into a massive constitutional issue.
We have to look closely at the governing law of the land at the time, which was the interim South African Constitution. It says, every accused person shall have the right to a public trial before an ordinary court of law within a reasonable time after having been charged. Now, that precise wording creates two incredibly tricky legal questions for us. First, what exactly is a reasonable amount of time? And second, when is someone officially considered charged?
Well, the Constitutional Court actually tackled that second question first. They decided to define charged really broadly. It basically means appearing in the dock for a formal remand. It doesn't just mean the moment you receive a neatly typed-up formal charge sheet. So for Sanderson, his constitutional clock didn't start in May 1996 when he finally got the paperwork. No, it started ticking the second he first appeared in court way back in December 1994.
Defining reasonable time. Now, that broad definition gives us a delay of nearly 2 years, which sounds like a lot. But is that inherently unreasonable?
To figure that out, we have to look at the Barker v. Wingo balancing test. It looks at the length of the delay, the reason for the delay, the accused's assertion of the right, and the prejudice to the accused. This framework actually originated from an American case, and the South African Constitutional Court used it to weigh the actions of both the prosecution and the accused on the scales of justice. It's essentially a 4-part checklist, and the most important factor on that list is the prejudice, or the actual harm suffered by the accused.
But you know, the judges were really careful not to just copy and paste American law. While North American courts might expect these super speedy trials and demand that an accused aggressively assert their rights, the South African reality is, well, it's entirely different. We're talking about a system with systemic delays, a resource-strapped transitioning justice system, and a huge number of citizens who don't even have legal representation or know they have a right to a speedy trial. The court had to be totally pragmatic and impartial about this heavily stressed legal reality.
Measuring the prejudice. This brings us to the absolute most critical factor in that balancing test.
We're looking at the actual tangible harm the accused suffers while the clock just keeps on ticking. The court breaks this down into 3 types of prejudice: social, which includes negative publicity, lost income, and stigma; liberty, meaning things like pretrial jail or restrictive bail conditions; and trial-related, which happens when memories fade or witnesses are lost because of the delay. The court made a huge point of emphasizing that this delay acts like an extracurricular punishment. Basically, you're punishing someone before they've even been proven guilty, which really undermines the whole presumption of innocence.
Applying those categories right back to our case study, Sanderson claimed severe social prejudice and trial-related prejudice. For the social side, he pointed to the extensive newspaper coverage that dragged his reputation as a teacher through the mud and pretty much halted his church and music activities.
On the trial-related side, he argued that since the events allegedly happened back in 1991 and 1993, a long delay meant the witnesses just wouldn't accurately remember what happened, or they might be influenced by other people.
But to be fair, we have to look neutrally at the state's side of the scale too. Their reasons for the delay: a complex investigation involving children, waiting for ministerial directives, scheduling conflicts with school holidays, and witness relocations in pregnancy. The prosecution was dealing with a total logistical nightmare. These were really delicate investigations involving kids and alleged offenses from years prior. They had to wait on special directives just to combine charges across different jurisdictions. Plus, coordinating around school holidays was a huge headache, especially when one key witness moved to a different province and another became pregnant.
The ultimate verdict. This brings us to the climax of our explainer. The court has to look at all these facts, weigh the harm against the delays, and make a final ruling on Sanderson's fate. So does the delay justify dropping the charges completely? Did Sanderson suffer enough prejudice to justify letting him walk away without a trial ever happening?
Well, to drop the charges entirely, you need a permanent stay of prosecution. This is a radical remedy, barring the state from ever trying the accused for the alleged crimes. It is a massive, extreme measure. It completely stops society from presenting its complaint and seeking justice. Because it's so incredibly far-reaching, a court is only going to grant this if the accused has suffered massive, totally irreversible harm.
Let's look at a nuanced breakdown of Sanderson's hardships versus the mitigating factors. Yes, he faced significant social embarrassment and canceled performances, but on the flip side, he didn't do any jail time, he actually kept his job as a deputy principal, he had lawyers, and even agreed to several of the postponements to fit his own schedule. Plus, and this is crucial, the court noted there was no actual trial prejudice. In fact, the passage of time regarding memories from 91 and 93 might actually help his defense team when cross-examining those young witnesses.
So, what's the verdict? The appeal is dismissed. The trial must go on. Based on all that balancing, the court determined that while a permanent stay of prosecution might make sense in some extreme cases, it absolutely wasn't warranted here. When you balance Sanderson's social embarrassment against society's profound need to investigate delicate charges protecting children, the scales tip firmly back toward continuing the prosecution.
But wait, there's a really surprising final twist here. The silver lining is that Sanderson does not have to pay the state's legal costs because he raised a genuine constitutional complaint. See, the lower court had originally ordered him to pay the state's massive legal bills for bringing this application, but the Constitutional Court totally reversed that. They ruled that because he raised a genuine, substantive issue about his fundamental rights, he shouldn't be penalized financially. It's a huge protection for future citizens, ensuring they aren't terrified of challenging the state just because they fear bankruptcy.
To really wrap up the legal philosophy we've been talking about, listen to this quote from Judge Kriegler. Delay cannot be allowed to debase the presumption of innocence and become in itself a form of extracurricular punishment. A person's time has a profound value. I think that perfectly captures the incredibly delicate tightrope the court has to walk. They have to protect the presumption of innocence in a free society while also acknowledging that, unfortunately, the justice system inherently imposes a heavy burden on the accused.
And that leaves us with this final question. When the justice system slows down, who really pays the price? We all benefit from a structured legal system, sure, but it's run by imperfect logistics, overstretched resources, and, at the end of the day, human beings. Is it the accused who pays the price, living under a dark cloud of suspicion, or is it society, forced to wait years for a resolution? Think about how this balance plays out in courtrooms every single day. Thanks for joining me for this explainer, and keep questioning the systems that govern us.